Good afternoon, President Simma and Judges Wedgwood and Alvarez. My name is Sebastián Machado, and it is an honor for me to appear before the International Court of Justice this afternoon, pleading on behalf of the Republic of Alicante. I will speak for the following 22 minutes, and I will be addressing Alicante's first submissions. The first one referring to the conduct to Ravisian intervention in Alicantan territory and how it contravenes international law, and I will then turn to the intelligence which was gathered to justify this operation. I will then yield the floor to my co-agent, Mr. Guillermo Talura, who will speak for 21 minutes, and he will address Alicante's last two submissions. The third one referring to the conduct of Ravisian troops while stationed at Camp Terra, and lastly, the assassin, Picardo Donati, and how he must be immediately delivered to Alicante to comply with his judicial sentence. In consequence, Your Excellencies, we will be reserving 2 minutes for our rebuttal. Mr. President, and may it please the Court. In December 2005, the United Nations Security Council adopted Resolution 5440, by which it authorized a peacekeeping operation inside the territory of Alicante. Once this operation was completed, Your Excellencies, notwithstanding the allegations of the sexual exploitation and the broadcasting, subject of our third submission, Ravisia decided nonetheless to intervene, circumventing the fact, Your Excellencies, that the Security Council rejected not once, but twice, an express proposal to intervene in Alicante. One of the reasons to intervene, Your Excellencies, was the assassination of Alicante's Prime Minister, Gregory Simma, but the assassin is at this very moment absconding at Camp Terra, under the jurisdiction of the respondent state, and he is the subject of our fourth submission. It is, Your Excellencies, the intervention in Alicantan territory after the adoption of Resolution 6620, which is of interest to the bench for our first submission. Your Excellencies, I will deal with two arguments in our first submission. The first one referring to the legal effects of Resolution 6620, and I will then turn to the more difficult question on this alleged rule of customary character, which allows for a third state to intervene when they consider that there is a humanitarian situation that so calls for this intervention. Your Excellencies, as to our first ground, Resolution 6620 is not an authorization for the use of force. It is not because a closer look at the practice of the Security Council will show that when the Security Council authorizes Chapter 7 missions, it uses three factors: a reporting duty by an intervening state, a very clear scope of a mandate, and a very precise language to authorize the mission. Your Excellencies, none of these factors are found in Resolution 6620.
Counsel, would you say that, for instance, the authorization given to a coalition in 1990 in Resolution 678 is a good example of a clear mandate?
It is, Mr. President, for one reason, and I understand your concern because Resolution 678 merely referred to the obligations set out in Resolution 6620. But it is in this sense that the mandate is very clear, that is to comply with the obligations to push Iraqi troops back into the state of Iraq. And that was a very clear language and a very precise mandate. Your Excellency, nonetheless, these resolutions and the operation in 1990 did include the other factors: reporting duty by the intervening states, and a very precise scope or language for the authorization.
As the President of the Tribunal, I think, though, is adverting, 678 did have some rather vague language, which spoke of the restoration of regional peace and security. So the Security Council does know how to talk in riddles when it wants to, does it not?
Your Excellency, I understand your concern, and Resolution 678 did not use express language such as to authorize the use of force, but it did make reference to the issue of necessity, the use of all necessary measures. And this term necessity, or the question of necessity, has been consistent in Security Council resolutions authorizing for the use of force, ever since the first resolution which authorized the use of force, Resolution 83 in 1950 against North Korea.
Counsel, I'm a little puzzled in that we're immediately jumping to trying to figure out what the Security Council is doing, which sounds like you're being asked, and I think this happens on the other side as well, to second guess the Security Council. Why exactly, other than the fact that you've agreed to be here, does this court have jurisdiction at all? It would seem to be the case that this case is, as the Security Council says in that very same resolution, seized of the matter. Why are we seized of it?
Your Excellency, that question was addressed by this court in the Tehran hostages case. And in paragraph 40, it clearly stated that when the council is seized of the matter in its political aspect, the court can very well be seized of the matter in its legal aspect. And that is precisely what we put forward before the court. And it is also important to note, Judge Alvarez, that in contentious cases before the court, there have been examinations on the legal effect of Security Council resolutions, such as the Lockerbie contentious case, by which the court had to analyze effects of council resolutions as to determine its jurisdiction.